back up here. Good morning, Mr. Pardee.
Good morning, Your Honor. May it please the Court, I represent the Department of Environmental Protection. The case before you arises under the Water Management Act, Chapter 21G, which was enacted in 1985. I believe it's the first case involving this statute that's been before the Court. And the issue, the primary issue before the Court is fundamental to the effective operation of the Act. The issue is, does the Act empower the Department to require those who withdraw water from the Commonwealth's water resources to implement measures designed to minimize waste and avoid depletion of the resource?
If I could
Mr.
ask,
Pardee? Go ahead. You go ahead.
let's assume you prevail here and you're allowed to impose conditions upon registrants, and let's assume the registrant does not comply with any of those conditions. What can DEP do within the context of this statute?
There is ample authority in Section 14 to enforce any of the requirements that the Department imposes.
By?
Including through administrative penalties, including through actions by the Attorney General to enforce, and also in egregious cases by criminal penalty. That's Section 14 of the Act. Section 14 also, by the way, gives the Department extensive authority to enforce the Act through orders. There is some argument, which I was not intending to address in detail, that the Department must take action through regulations, but Section 14, among other things, clearly refutes that contention because it gives the Department the authority to issue any order that it deems necessary to carry out the purposes of the Act.
You argue, I mean, I think you concede that for these towns that have registration statements, that there is no authority to limit, at least to cut back from what they've been grandfathered in terms of total, right?
No, that's not accurate, although I don't think the Court needs to reach this issue in this case. Our contention is that the provisions that we're talking about, which have to do with the allocation of water resources, must be seen in the context of Section 3. And Section 3 itself gives the Department the authority through regulations or through actions to take any action that it deems necessary to, among other things, ensure a balance between uses and withdrawals.
But if you have, I thought you were agreeing you weren't cutting, but I mean.
These conditions do not cut back on the amounts in the registrations.
Right. But you're saying that you say we don't need to reach that, but you think you've got the authority to cut back the amounts in the registrations?
We do.
Even with the specific language in Section 5?
I don't believe that Section 5 it can be read as an absolute grant of authority. If you look at Section, if you look at the Senate report, for example, what the Senate report says about registrations, and it's I'll give you the exact language. It partially quoted in the town's brief at 3, but not fully quoted. It says.
You're talking about Section 5?
No, I'm now referring to the Senate Select Commission on. They discussed the purposes of registration, including Section 5 and Section 6. And what the Special Commission said was that these provisions provide the minimum allocation regulation consistent with the Act's management objectives. But the next sentence says the purpose of these provisions is to enable data gathering, registration and permitting, so as to enable comprehensive regulation of ground and surface water withdrawals.
But what do you do about the last paragraph of Section 5? Upon
Upon
The registrant shall be entitled, upon the filing of a renewal registration statement, to continue existing withdrawals specified in the registration statement for a period of 10 years.
The way we view this section, this provision is, first of all, taking note that the provision requires renewal every 10 years.
Right?
And taking into account, again, the extremely broad language in Section 3, which states, again, to quote, that the department may take action, any action that it deems necessary or appropriate to ensure balance. If you posit a circumstance where the combined registrations, let's put aside permitting, but the combined registrations within a river watershed were now exceeding a level such that the river was not flowing adequately to support fish habitat or to support fully the needs of residents in the watershed to water, the department, under that provision in Section 3, would have the authority to reduce an allocation to ensure balance between all the demands on that watershed.
Mr. Putty, you keep saying, well, the department has the authority under Section 3 to take any action, and you're referring to necessary to carry out the purposes.
Right.
It really doesn't say that. It says shall adopt such regulations as it deems necessary to carry out the purposes. We don't have any regulations here on.
Well, there are regulations that talk about putting conditions on registrations. Let me back up and say once again that this discussion we're having about reducing allocations is not presented in the case. It is, in response to a question, yes. The
the question is whether I think it is a little presented.
The actual question before the court is whether the department has the authority to require registrants
to impose conditions for registration.
To impose conditions requiring registrants to use water efficiently without waste, and having it taking into account the stress within a river basin during the hot months in summer. There is nothing in those conditions that reduces the volume that's allocated through the registration.
And those are conditions that you promulgated by regulation, saying conditions can be imposed on registrants as a part of the registration?
The department has promulgated a regulation. It has been on the books since 1987, stating that it has the authority to impose conditions, including but not limited to conditions listed in the regulation.
I'm sorry.
And what is it? What is listed in that regulation?
Well, the regulation lists the statutory the items that are addressed in the statute. The statute, by the way, uses the same terminology in Section 6 that the
Right.
registration must include at a minimum
But it
the
does.
following.
But Section 6 starts by saying something about the department by regulation. So are you saying that you've already done that?
I'm saying the department has provided in a regulation that it may impose additional conditions, but there is not anything in the statute that says specifically that the department must promulgate conditions, that word, in regulations. And in fact, the only section that uses the term conditions makes it clear, that's Section 11, makes it clear that conditions, whatever you may say about other requirements of the department, conditions need not be promulgated, because that section says with regard to permits, the department may impose in a permit any condition.
Yeah, you got specific authority for that
Right.
in the statute.
Yeah. But my
And you're
point
just saying
is
we can
that-
also do it on others who are grandfathered just because we've got this general authority to promulgate regulations.
Well, I think that you have to understand, first of all, that the allocation provisions, and this is quite clear in the Senate Commission, the purpose of the allocation provisions was to eliminate or replace the common law system where a person who has a well is not protected from a person later coming on and drilling a well and drawing down so far that the first person's well runs dry. What the allocation provisions establish for the first time is that those withdrawals that were in existence when the statute was enacted may continue and are entitled to continue vis-a-vis other people who may drill. But that's all the allocation provisions are concerned with, is the right to drill and withdraw. There are many other demands on the water resources, and they are not precluded from consideration by either Section 5 or 6 or 7 or 11. Those provisions are dealt with in Section 3. And that's why I say that you have to read the allocation provisions embedded in the context of the statute as a whole, including, very importantly, Section 3, which I might add the towns, neither the towns nor the Superior Court once addressed as bearing on this question.
Section 3 is noted by the Superior Court.
But these provisions that we're relying on are not discussed by the Superior Court, and they are not discussed by the plaintiffs.
Mr. Pardee, just as a matter of curiosity, if a registrant drills down to X feet into the aquifer, and the aquifer becomes overdrawn, and the registrant wants to drill down further, does the registrant is the registrant entitled to drill down further by virtue of the registration, or must the registrant apply for a permit to drill deeper?
If it were a separate well, it would be a new permit. I am not honestly sure whether drilling deeper in the same well would require a permit or not. It might very well. The registration is meant to establish the right to draw the volume from the well that was in existence, is my understanding of it.
Okay, so towns grow and they need more water. They need more water beyond their grandfathered allocation.
Right.
They have to get a permit, or they do something else?
They have to get a permit.
Okay,
Or
and
they
you can attach conditions to permits.
Yes, you can, but
Like you need to conservatively use your existing water in order to get more, something like that?
well, I'm sure that the towns would argue that to the extent that the conditions that were imposed, the problem is that a water supply does not differentiate between water that's drawn from a
Understood, but if you want a
permitted well and
permit
one
to
that's
draw
drawn-
more water, you've got to demonstrate as a condition of that permit that you're using the existing water in an appropriate
65
fashion.
gallons per day, or whatever it is
Fine,
that you want
all
to
right.
do.
I'm just
Let's
wondering.
assume it's so, although I think it's a separate lawsuit.
I'm just trying to understand how a town gets
What I would,
access to more
what I
water.
would point out, yes, it would be through a permit. But what I would say is, first of all, that in many watersheds, even with just registrations or registrations and a very little bit of extra pumped above, in fact, the towns note that they're not even drawing in some years. In 2007, for example, they were not pumping their full allocation. Nevertheless, across the Commonwealth, watersheds are in a stress condition. And the statute here was enacted to deal with the problem of limited resources. There was a time when we thought Massachusetts had unlimited water resources. That we were disabused of that, and I hope we haven't forgotten that
Going back to the language of the statute, which appears to be some compromise here between those which may register and those which require permits. They don't need permission to register. They can just register. Is it your position that with regard to the conditions you impose, I gather you're saying that if Fairhaven fails to comply with those conditions, you can cut back on their allocation?
the department is highly unlikely to
I'm not
reduce.
saying what they're likely to do. I'm saying, are you empowered to do that? Do you have the authority to say?
I am saying that the department, if it made a finding, as envisioned in Section 3, that it needs to take action with respect to allocation amounts in order to achieve balance, it may do so. But in terms of enforcing conditions, I think the department is going to go by way of its power under Section 14, because after all, we recognize these are registrations for drinking water, and the department isn't likely to take action that reduces the supply of drinking water.
And apart from what you're likely to do, or you also say you are empowered to say you've lost the ability for us to renew your registration because you failed to comply with your conditions
Well, the
in the
department,
last
the
registration.
department's regulations do say that if a registrant on renewal fails to file a complete renewal form, they could lose their.
They file a complete renewal form, but they don't comply with the conditions which you're now seeking to impose. Are you saying you can say, sorry, we shall not register you and you must now proceed by permit?
I think the department's regulations do reserve that power with respect to registrations. Yes.
Thank you, Mr. Pardy.
Thank you.
Mr. Henshey?
Good morning, Your Honor, and may it please the Court. My name is William Henshey. I'm an attorney from Orleans, Massachusetts, and I represent the town of Wellesley, the Sandwich Water District, and the Mashpee Water District, and along with Mr. Corbo, we'll be arguing for the appellees.
What about Section 3? That's pretty broad language, isn't it? Isn't
Well,
it a mission statement?
Your Honor, some parts of it I would suggest are fairly broad. Some parts of it I would suggest are not so broad. And certainly not nearly as broad as the Department of Environmental Protection would have the Court agree. There is general language. Well, let me back up just a bit. I believe that Section 3 sets out a couple of things. It establishes, I would suggest, a planning process for new withdrawals and future withdrawals. And I think that distinction under the statute is critical to the matter that is before the Court, because the statute...
Well, except that what's at issue here, I mean, yes, in some cases, but nobody here is asking you to reduce your withdrawals, right?
That's not correct, Your Honor, not at the present time, but the Department...
Well, not at
is
the
ex-
present time, so
That's
it's
the case
not
we have.
here.
What in the case that we have, the Department is explicit at pages 5 and 6 of its reply brief that it believes it has the power, notwithstanding the plain language of Section 5.
It's not here. They haven't told you to withdraw, correct? Okay. So what we have, and I'm not saying your clients are this, we have very, very broad language in Section 3, and nobody would disagree as to what that language is and what the purpose of the statute is. And the purpose of the statute is Commonwealth, 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 Commonwealth. That's what the statute is. Now, people in New Hampshire may not like that, people in Rhode Island may not like that, but we're looking at the Commonwealth, right? We've got two groups of people. We've got a group of people who have already been given authorization to withdraw X, right? And we've got people who haven't been given any withdrawal. But it turns out that the people who have been given the authorization are really profligate. I mean, they are burning through that water as if there was no shortage anywhere in the world. Right?
Well,
And that's
certainly
having a
not what we
terrible
was-
impact on the people who are asking for a permit. It's having a terrible impact. And you're saying tough. Am I correct?
I wouldn't say tough, but I would say, Your Honor, that
No,
was
just too bad. Too bad. Sorry, this department, this entity, this organization that is to look at the whole Commonwealth and make sure that all of us and our children and our grandchildren and our great-grandchildren have enough water to drink. You've got some parts of the Commonwealth that just say, too bad. Nothing they can do?
under the statute, Your Honor. What they can do is they can go to the legislature and seek an amendment to the authority that they were given. Because in answer to Justice Cordy
And you think that's a reasonable interpretation when they were talking about Commonwealth, 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 Commonwealth?
I do, Your Honor, and
Okay.
may I explain. Section 3 of the Act sets forth an explicit language in addition to the sort of planning process that's outlined in the Water Resources Commission and so forth, and a general authority to adopt regulations to effectuate the purposes
But long
of the
before
Act.
you get to the regs, let's just start at the beginning of Section 3. Paragraphs before you get to the regs: effective planning, management of water use, conservation in the Commonwealth, administration necessary and proper to ensure adequate volume and quality of water for all citizens of the Commonwealth. Again, keep in mind, I'm not saying that your clients are being profligate, but as I understand your answer, it is too bad. I'm just going to spray that water into the hot sun day in and day out, 365 days, because I have got a legislation statute that lets me use this much water. I don't care about the rest of the Commonwealth.
I have to respectfully disagree with the premise of your question, Your Honor, but accepting that as a hypothetical,
Right?
I would suggest to the court that the following is the correct analysis. If one looks at the Special Legislative Commission, which generated the progenitor of this statute, that legislative commission was explicit that it was proposing a system which would do a number of things. It would contain a planning process for future withdrawals. It would contain a registration process for existing withdrawals and a permitting process for new withdrawals above a threshold volume that was set initially, and TEP has the power by regulation to change. Now, as to the registrations, the Special Legislative Commission is explicit that the purpose of the registrations is a record-keeping and a bookkeeping and an information supplying purpose, so that the Department of Environmental Protection would have a baseline, bless your honor, so that the Department of Environmental Protection would have a baseline of the volume of water which was being withdrawn throughout the Commonwealth, a number of which prior to the adoption of the statute, I would suggest, did not exist. And I would suggest to the court that it is a perfectly rational and appropriate construction of this statute. And by the way, the Department of Environmental Protection, at the time the statute was promulgated, stated in materials that are in the record and which we've cited in our brief, that the purpose of registrations was to provide to the department a baseline of water that was being withdrawn so that the department may plan for future withdrawals. Now, I suggest to the court that that's a perfectly rational statutory scheme, not only on its face, but when one considers the difficulty of obtaining the passage of a statute that is going to affect drinking water in 351 cities and towns throughout the Commonwealth, that it's certainly rational for the legislature to place into the statute a provision that says existing users, provided that they register, and provided that they conform to the registration statements, and provided that they renew, shall be entitled to continue those renewals.
Mr. Henchy, let me ask you this. So if you look at 36.02, the opening purpose,
You in the regulations,
Yep.
Your Honor, of the statute?
yeah, is intended to establish a program whereby withdrawals of water in the Commonwealth above a threshold quantity are registered and regulated by the Department Division of Water Supply.
Yes, Your
Is that an okay statute?
Honor. That is the.
Regulation?
Most of it. It is the department's language, for starters. It's not the legislature's language.
No, I understand. I'm just asking if you're telling me that's an okay rig.
I do not agree with so much of that regulation as would suggest by implication that registered volumes may be, quote, regulated by the Department of
Well,
Environmental
what would
Protection.
prevent somebody from going into the town of Sandwich, for instance, and opening up a water bottling company, just drawing down the aquifer and selling it to people in some town that whose wells don't reach down as far because they're permitted. They're only permitted. They're not registered.
That hypothetically, Your Honor, would be precluded by the statute because if you are withdrawing water from an aquifer above the threshold volume, and it's presently 100,000 gallons a day.
No. Let's say that how much are you actually using? How many 100,000 a day? So
Well, my observation is DEP can adjust that down to 1 gallon per day. So the threshold can be anything the department says it has
what?
to be.
They can adjust it down to 1 gallon a day?
The threshold for permits for new withdrawals.
Oh, that's it for
Okay?
permits.
And the language in the regulation you cited, Your Honor, Madam Chief Justice, the threshold language refers to that threshold volume, and that is for new withdrawals. What this case involves.
But it says are registered and regulated. When was this regulation promulgated?
This regulation, I believe it was back in 86, 87, Your Honor. It was at the inception of the program.
Why would you need to keep registering if you're totally grandfathered?
Well, I think it's rational, Your Honor, for the legislature to require registrations to be renewed.
Why?
Because public water suppliers are not the only registrants. In Cape Cod, for example, cranberry growers and other agricultural uses are registered in some
No,
cases.
but once you register,
Why would any registrant have to keep registering if they can forevermore do exactly what they were doing from 1981 to 1985?
Well, because some of them go out of business, Your Honor. Cranberry growers go out of business. Golf courses go out of business.
But that's the only purpose. It's just to keep track that they still exist.
The department might want more data, I assume.
I was going to say, I think in consistent with the record-keeping function of registrations, which is to provide for the department the baseline value of water that's being withdrawn under registrations, that it is certainly rational and permissible to require a registrant to pop up every 10 years and say, we are still here, we still intend to continue our existing withdrawal. And if one does not in that situation, the right to the existing withdrawal under the statute disappears. And if one wishes to engage in a new withdrawal, the bottling company, Your Honor, that you referred to, then one must seek a permit for a new withdrawal. And permits for new withdrawals, as I think has been observed by the court and by everybody.
Why is that a new withdrawal? You're using the existing well, the town's existing well.
The statute, Your Honor, defines new withdrawals and existing withdrawals in Section 2, I believe, of the Act. And an existing withdrawal is any withdrawal that was engaged in prior to January 1 of 1986 and which is registered in accordance with the provisions of the Act.
But does everybody who uses municipal water have to register? Isn't it just the town that has to register?
Well, if one was withdrawing water prior to January 1 of 1986, Your Honor, one would have to register that supply in order to have the benefit of the protection in Sections 5 and 6 that we argue pertain to these registrations.
But the homeowner isn't the registrant.
No, unless the homeowner, Your Honor, for whatever reason, and there are some irrigation systems that generate this volume of water, withdraws more than 100,000 gallons per day. And in that instance, a homeowner would have to apply for a new permit or be eligible for a registration as having withdrawn that volume of water prior to January 1 of 1986. I believe I'm going over my time and into Mr. Corbo's time. I don't want to do that.
You don't go into his time. It's okay.
Oh, okay. I'm sorry, Your Honor. And the answer to your question, Your Honor, lies in the definitional sections in Section 2 of the statute. An existing withdrawal is a withdrawal which took place prior to January 1, 1986, and which is registered. Everything else is a new withdrawal, and everything else is subject to the Act's permitting provisions. And if one thinks about this...
Now your time is up. Now you're going into further argument. You're not answering
Are there
just...
any other questions? And I'll take the hint, Your Honor.
Thank you very much,
Thank you
Mr.
very much,
Henchy. Mr. Corbo?
Good morning. May it please the Court. My name is Greg Corbo, and I will be presenting the appellee's position on the issue of exhaustion of administrative remedies.
Could I know I should have asked this before, but if I could. With respect to Section 6, do you think that the department could, by regulation, require, as part of the registration statement, something along the lines of, as a conservation measure, you need to do X, Y, and Z?
No, Your Honor. We don't interpret Section 6 that way, nor do I think it can be interpreted that way. And it comes down to how you define what a registration statement is. The department would have you define a registration statement as something that the department gives to the water user. We're giving you a statement that says you can use this amount of water. But the way that the term is used in the Act, it's something very different than that. A registration statement is something that the user gives to the department, and it says, Department, this is the amount of water that we are using. So when Section 6 talks about the contents of a registration statement, it's for informational purposes. Tell us what it is that you're doing with the water.
So even if there were no new permits, you have circumstances in which an aquifer is going down in water level. You have existing registrants that are drawing it down, but so are people in nearby states drawing it down. So it's going down faster than the Massachusetts registrants are drawing it down. You mean the department cannot say to those registrants, you have to reduce the withdrawal, the rate of withdrawal from the aquifer? They can't. The state can't do that?
That's correct, Your Honor.
Not only can they not do that, you're saying they can't even say, and by the way, we're not even going to ask you to reduce, right? We are going to ask you, please not just to open all the fire hose spigots and just have the water running down the drain into, some sewer someplace. We're just going to ask you not to do that because, the aquifer is going, the water table is going lower and lower and lower, and you're saying can't do that.
They can't require it. As long as you are within your registered volume, the discretion is upon the user to use that water to fit their needs. And Justice Spina, to answer your question, it does not appear that that is a circumstance that the legislature anticipated when the act was enacted. The act is clear that once you have your registered volume, you are entitled to continue that registered withdrawal as long as you renew
Well,
every
then
10
why
years.
should you be required by statute to tell of the occasion that you tell us that, that you're re-upping for 100,000 gallons a day, what your conservation measures are? What do you care?
It's for planning purposes.
I
And,
think what?
well, because,
It doesn't make any difference. You're going to use up 100,000 gallons a day.
well, not necessarily.
Sure you are, because you've got the right to do it, and they can't tell you not to.
But just because you have the right to do it doesn't mean that you are. And the
No,
purpose of
but I mean,
renewing-
so stay out of my business. I'll do my conservation. This is the legislature speaking. This is not the regulation. This is the legislature speaking. I want to know what your conservation efforts are. And you like none.
And in terms of planning, if the registrants have no obligation and the state can't require them to reduce their withdrawals, nobody can move in. I mean, there's a scenario in which nobody could move into the surrounding areas to drill new wells because there's just not enough water left.
Well, I think that's the point here, is that the purpose of the reporting and the registration is to enable the department to determine how it's going to respond to applications for new withdrawals. What's clear here is that it was anticipated that the registrations would not be the be-all and end-all here, that there would be applications coming in for permits for new withdrawals. And what the legislature was saying was that, okay, in order to make informed decisions about how much water to give out in those new withdrawals, we need to have accurate information about what's being done with the existing withdrawals. So we're going to come up with a scheme that requires reporting, detailed reporting about how much water you're actually using, what you're doing to conserve the water that you have, so that we know this is what we can give out in new withdrawals.
Counsel, you can turn to your argument now. I'd like to actually hear you on why the department can't set up an administrative adjudicatory process, essentially.
Thank you, Your Honor. And these issues are interrelated in that they really go to what is the scope of the department's authority under this act. And you have this Section 3 that the department is holding up as being this all-encompassing catch-all. We can do whatever we want under Section 3. But that ignores the fact that what you have here is a very comprehensive statutory scheme that sets forth a number of specific requirements and limitations on the department's authority.
Well, let me ask you this. Let's assume for a moment that we conclude that perhaps certain conditions on registration statements or registered water users can be imposed, but that this is a matter that has to be done by regulation, which the statute may suggest. Regulation is the way you do it. Certainly in those circumstances, don't you think that the department would also be able to set up a system by which persons who are regulated and conditions on whom conditions imposed can essentially appeal those conditions?
In that circumstance, Your Honor, if the department was going to have the authority to enact a regulation imposing conditions on registration statements, and they, by regulation, also said, and you can request an administrative hearing if you are aggrieved by the imposition of such conditions, that might be a different case.
Okay.
We don't have that here. There is no regulation that authorizes an administrative appeal here or requires an administrative appeal here.
Well, do you contend that the department could not promulgate such a regulation? Could the department, by regulation, set up its own internal adjudicatory process?
Under the circumstances of this act, no, it cannot, because you have to look at the act as a whole. And although you have this general grant of authority in Section 3, that general grant of authority is shaped by the more specific provisions that come later. And in particular, you have Section 12, in which the legislature specifically said there are two circumstances under which the department can conduct an administrative proceeding. By a person aggrieved by a permit or an addition to an existing withdrawal. It did not specify conditions upon registration statements, and the legislature certainly could have. You can't just add words to a statute because it seems imprudent at some future later date. And to sort of bookend our case here, that omission is significant because what it shows is that
Suggests there's nothing to adjudicate.
Exactly. That the department never intended that there would be any exercise of discretion by the department with respect to registration statements. With that, my time is more than up. I'm happy to field additional questions.
Thank you.
Thank you.